Hello everyone and welcome back to this channel. So today we will be talking about section 167 CRPC. So section 167 talks about procedure when investigation is not completed within 24 hours. अगर 24 घंटे के अंदर अंदर इन्वेस्टिगेशन कंप्लीट नहीं होती तो क्या प्रोसीजर फॉलो किया जाएगा, दैट इज गिवन अंडर सेक्शन 167 CRPC. So let's begin. A police officer, as you all know, cannot detain an accused person arrested without warrant for more than 24 hours. This is given under section 57 of criminal procedure code. What does it mean? कि कोई भी पुलिस ऑफिसर किसी भी एक्यूज्ड पर्सन को जिसे बिना वारंट के अरेस्ट किया गया है उसे 24 घंटे से ज्यादा समय के लिए डिटेन करके नहीं रख सकते. If the police officer considers it necessary to detain such accused person for a longer period for the purposes of investigation, then section 57 mandates that he can do so only after obtaining a special order of a magistrate under section 167. मतलब पुलिस ऑफिसर के पास पावर है कि वो 24 आवर्स जाने के बाद भी उस एक्यूज्ड पर्सन को डिटेन करके रख सकता है, बट he has to take a special order from a magistrate as per section 167 of CRPC. Now, what is the object of this section? What is the object of incorporating this concept in CRPC? When any investigation cannot be completed in 24 hours and the accusation is well founded, the police officer is required to send a copy of the entries in the diary relating to the case along with the accused to the nearest magistrate. The object is to enable the magistrate to see that if remand is necessary. मतलब जो भी पुलिस ऑफिसर ने अपनी डायरी में रिकॉर्ड किया होगा वो एंट्रीज अलोंग विद द एक्यूज्ड पर्सन, वो दोनों चीजें डायरी भी और एक्यूज्ड पर्सन को भी मजिस्ट्रेट के सामने पेश किया जाएगा. एंड इस चीज का ऑब्जेक्ट क्या है? टू एनेबल द मजिस्ट्रेट, मजिस्ट्रेट ये पता लगा पाए कि रिमांड नेसेसरी है या नहीं है. The object of requiring the presence of the accused before the magistrate for the purpose of remand is only to enable him to make representation he wishes to make in the matter. So, what is the analysis of section 167? Let's understand it with a flow diagram, flow chart. Whenever any person is arrested and detained in custody, and it appears that the investigation cannot be completed within 24 hours, and there are grounds for believing that the accusation or information is well founded, जो भी उसके ऊपर आरोप लगाए गए हैं या जो भी इंफॉर्मेशन उसको लेकर पाई गई है, it is well founded, वो सही पाई गई है, then the officer in charge of the police station or the officer making the investigation shall forthwith transmit a copy of the entries in the case diary to the nearest judicial magistrate. Now, and shall that magistrate shall also at the same time, that police officer shall also at the same time forward the accused to such magistrate as per section 167 clause 1. For invoking section 167 clause 1, it is necessary that the arrest should have been made only by a police officer and none else. And there is no need not necessarily be the records of the entries in the diary. Now, the custody can be police custody or judicial custody. Two types of custody: police custody or judicial custody. The judicial magistrate to whom the accused is so forwarded may, whether he has or has not jurisdiction to try the case, जिस जज के पास, जिस मजिस्ट्रेट के पास एक्यूज को ले जाया गया है उसके पास jurisdiction हो या ना हो, from time to time that particular magistrate can authorize the detention of the accused in such custody as he thinks fit for a term not exceeding 15 days. 15 दिन से ज्यादा वो उसको कस्टडी में नहीं भेज सकते वो मजिस्ट्रेट. दिस इज एज पर सेक्शन 167 clause 2. Now, if that magistrate has no jurisdiction to try the case, then what? And considers further detention necessary if that magistrate, जिस magistrate के पास accused को ले जाया गया है, and that magistrate is not having jurisdiction, और उस मजिस्ट्रेट को ये लगता है कि फर्दर डिटेंशन भी जरूरी है, मतलब 15 दिन से ज्यादा भी उसको डिटेन किया जाना चाहिए, then what? He may order the accused to be forwarded to a judicial magistrate having jurisdiction. जिस मजिस्ट्रेट के पास jurisdiction है, उस मजिस्ट्रेट के पास उसे फॉरवर्ड कर दिया जाएगा. Now, when a person is arrested and produced before a magistrate, the magistrate can remand him to police or judicial custody for 15 days at the first instance. पहले पहले वो सिर्फ 15 दिन के लिए ही कस्टडी में भेज सकते हैं. Within this period of 15 days, इन्हीं 15 दिन के दौरान there can be more than one order changing the nature of such custody either from police to judicial or vice versa. अगर पुलिस कस्टडी दी गई थी तो जुडिशियल कस्टडी में चेंज कर सकते हैं, और जुडिशियल कस्टडी दी गई थी तो पुलिस कस्टडी में चेंज किया जा सकता है. आफ्टर द एक्सपायरी ऑफ दिस फर्स्ट पीरियड ऑफ 15 डेज, जो ये पहले 15 दिन का समय है, ये खत्म होने के बाद द फर्दर रिमांड कैन बी टू जुडिशियल कस्टडी ओनली. ये 15 दिन का टाइम पीरियड खत्म होने के बाद सिर्फ जुडिशियल कस्टडी ही दी जा सकती है. नाउ व्हाट? There is also a provision of default bail under this section. Default bail under default clause proviso, this is provided under section 167 clause 2 proviso. The right to bail under section 167 clause 2 proviso A thereto is absolute. Now, what is this default bail? If the investigating agency fails to file charge sheet before the expiry of 90 or 60 days, as the case may be, the accused in custody should be released on bail irrespective of the order passed under section 439. अगर इन्वेस्टिगेटिंग एजेंसी जो इन्वेस्टिगेशन कर रही है केस का, अगर वो चार्जशीट फाइल नहीं कर पाती है बिफोर द एक्सपायरी ऑफ 60 और 90 डेज एज पर द केस, तो एक्यूज्ड को डिफॉल्ट में बेल मिल जाएगी बिकॉज ऑफ द डिफॉल्ट ऑफ द इन्वेस्टिगेटिंग एजेंसी. वो टाइम से चार्जशीट नहीं फाइल कर पाए 60 या 90 डेज के टाइम पीरियड खत्म होने से पहले, द एक्यूज्ड विल ऑटोमेटिकली गेट द राइट टू गेट बेल. The period of 90 or 60 days has to be computed from the date of detention as per the order of the magistrate and not from the date of the arrest by the police. जिस दिन मजिस्ट्रेट ने ऑर्डर दिया, ये 60 या 90 डेज का टाइम पीरियड उस दिन से शुरू होगा, ना कि उस दिन से जिस दिन से पुलिस ने एक्यूज्ड को अरेस्ट किया. Now, what is the object of incorporating this concept under this section? The object of incorporating the proviso here under this section 167 is to see that the person arrested by the police does not languish unnecessarily in prison awaiting completion of investigation. मतलब इन्वेस्टिगेशन को क्या पता कितना समय लग जाए, तो इसका मतलब यह नहीं कि वह एक्यूज्ड को अपनी कस्टडी में रखे जाएंगे अनलिमिटेड टाइम पीरियड के लिए. So this concept is given under this section. The provisions contained in section 167 clause 2 are mandatory. There is one landmark judgment, Changanti Satyanarayan versus State of Andhra Pradesh, 1986. It has been held by the court that the period of 90 days under section 167 clause 2 of the code shall be computed from the date of the remand of the accused and not from the date of his arrest as per section 157 of the Criminal Procedure Code. Now, we will talk about the concept of remand. The word remand has not been defined in the code. However, it is used in section 209 and 309 of the code. Generally, when a prisoner is sent back to custody by a court or magistrate after a preliminary or partial hearing of the case to be reproduced on the next date fixed, the prisoner is said to have been remanded to custody. Now, authorizing the detention on remand means the magistrate to whom the accused is forwarded may authorize the detention of the accused for a term not exceeding 15 days. There is another landmark judgment, Manubhai Ratilal Patel versus State of Gujarat, 2013 case. In this case, it was held that an order of remand is a judicial order. An order of a remand is a judicial order passed in exercise of a judicial function. Such function cannot be passed mechanically, and there must be special reasons must be given for extending the period of remand originally granted. There is another part of this section that is that deals with the duty of magistrate. When an under trial prisoner, when an under trial prisoner is produced before the magistrate after the maximum period of 90 or 60 days, it is the duty of the magistrate to inform that under trial prisoner. It is his duty to inform him that he is entitled to be released on bail. So the magistrate or the sessions judge before whom that under trial, before whom that accused person is presented, that magistrate is under an obligation to inform the accused that if he is unable to engage a lawyer, if he is unable to engage a lawyer on account of poverty, अगर वो गरीब है इसीलिए एक lawyer को नहीं ला पा रहा है, he is entitled to obtain free legal advice, free legal service at the cost of the state. So you might be aware of this provision under Article 39A of the Constitution. The Supreme Court has given necessary directions. Supreme Court ने directions भी दिए हैं इसको ध्यान में रखते हुए to magistrates, sessions judge and state governments with guidelines to be followed in this regard. Now, what is that case wherein guidelines are given by the Supreme Court? That case is Khatri versus State of Bihar, 1981. Now, detention in contravention of provisions, violation of right to life. When there is detention in contravention of provisions, जब अभी तक हमने जो भी प्रोविजंस पढ़े, अगर इन प्रोविजंस के अगेंस्ट में जाके कोई भी डिटेंशन होता है, किसी भी एक्यूज को कस्टडी में रखा जाता है, डिटेन करके रखा जाता है इन प्रोविजंस के अगेंस्ट जाकर, तो दैट कम्स अंडर द वायलेशन ऑफ राइट टू लाइफ. The Supreme Court in the case of Uday Mohan Lal Acharya, this is very landmark judgment, Uday Mohan Lal Acharya versus State of Maharashtra. So the Supreme Court in this case is of 2001. The Supreme Court observed that personal liberty is one of the cherished objects of the Indian Constitution and deprivation of the same. अगर किसी को भी, किसी भी इंसान को, भले ही वो accused क्यों ना हो, अगर उसे उसकी right to life से deprive किया जाएगा, then deprivation of the same can only be in accordance with law and in conformity with the provisions of thereof. तो जो भी लॉ में प्रोविजंस दिए गए हैं उन्हीं प्रोविजंस को ध्यान में रखते हुए ही आप उससे उसकी राइट टू लाइफ ले सकते हैं, अदरवाइज इट इज नॉट पॉसिबल इन एनी केस. Now, further investigation and the expiration of the period. This is another concept covered under this section. Further investigation, what does it mean? Where a person is arrested during further investigation, the court can, even after taking cognizance, of an offense, authorize detention in police custody. The words that are used here in this section are the accused if in custody. So what does it mean? The words the accused if in custody in section 309 clause 2, section 309 clause 2 में जो ये words use किए गए हैं, the words are the accused if in custody. Do not refer to a person who is arrested. सेक्शन 309 क्लॉज 2 में जो ये वर्ड्स इस्तेमाल किए गए हैं, the accused if in custody, ये do not refer to a person who is arrested in the course of further investigation. Now, this was held in the case of State versus Dawood Ibrahim 2000 case. On the expiry of 60 days from the date of the arrest of the accused, on the expiry of the 60 days time period, his further detention does not ipso facto become illegal or void. अगर 60 दिन का समय पूरा हो चुका है तो और उसके बाद भी उसे डिटेन किया जा रखा है एक्यूज्ड को, तो that fact does not ipso facto become illegal or void, that detention. But if the charge sheet is not submitted within the period of 60 days, अगर चार्ज शीट उस 60 दिनों के दौरान नहीं सबमिट की गई है, then the accused would be entitled to an order for being released on bail on if he is prepared to and furnishes the bail. अगर accused ready है bail भरने के लिए, if he is prepared to and furnish the bail. This was held in the case of state of UP versus Lakshmi Brahmananda. Now, release on bail after 90 days expiry period. The provision for release is mandatory in the sense that the accused shall have to be released on bail if he is prepared and does furnish the bail on the expiry of the period of 90 or 60 days, whatever the case may be, if the charge sheet is not filed within the said time period. For the release of the accused on bail under default clause in computation of the period of 90 days, the date on which the accused was remanded to judicial custody is to be excluded. I am repeating it again. For the release of accused on bail अंडर डिफॉल्ट क्लॉज, अगर डिफॉल्ट क्लॉज में हम किसी भी एक्यूज्ड की बेल डिमांड करते हैं फॉर द रिलीज ऑफ द एक्यूज्ड ऑन बेल अंडर द डिफॉल्ट क्लॉज इन कॉम्प्यूटेशन ऑफ द पीरियड ऑफ 90 डेज, तो 90 डेज का अगर हम टाइम पीरियड कंप्यूट कर रहे हैं तो द डेट ऑन विच द एक्यूज्ड वाज रिमांडेड टू जुडिशियल कस्टडी इज टू बी एक्सक्लूडेड, उस डेट को एक्सक्लूड कर दिया जाएगा जिस दिन उसे जुडिशियल कस्टडी के लिए रिमांड किया गया था. Thus, where the charge sheet was filed on the 90th day, it was held that there was no infringement of section 167 clause 2 of the code. Now, time for completion of investigation, let's talk about it. It is true that the code does not provide any specific time or not in terms say that inordinate delay in investigation beyond this period would vitiate the investigation. ऐसा कहीं भी नहीं लिखा है कि इतने दिन अगर investigation complete नहीं हुई तो इसके बाद the proceedings the investigation would be vitiated. Nowhere it is written. So, but it does speak about the speak of the legislature's concern about the speedy conclusion of the investigation. So our legislature is concerned that there must be a speedy investigation. That concern is majorly focused here. Section 167 clause 5 and clause 6 have been introduced with a view to see that there is not unnecessary delay in investigation. An inordinate delay encroaches upon the right of speedy trial. So this right of speedy trial is a fundamental right given under Article 21, covered under Article 21, that is right to life and personal liberty. So this, if there is an inordinate delay, अगर बिना किसी reasonable, बिना किसी justifiable reasons के अगर the investigation में delay हो रहा है, तो then that is the infringement of right to speedy trial of the accused. The outer limit of 6 months can only in exceptional cases, on the satisfaction of the magistrate or the sessions judge be extended. Now, section 167 clause 5 lays down that if in any case triable by a magistrate as a summons case, the investigation is not concluded within a period of 6 months from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation of the offences unless the officer making the investigation satisfies the magistrate that for special reasons and in the interest of justice the continuation of the investigation is necessary. Now what does it mean? Section 167 clause 5 ये कहता है कि अगर 6 months का time period cross हो चुका है from the date of the accused the arrest of the accused took place, उस तारीख से अगर 6 months का time period cross हो चुका है तो then the magistrate or can make an order, magistrate shall make an order, magistrate order करेगा, ऑर्डर पास करेगा कि आगे इन्वेस्टिगेशन नहीं की जाएगी. लेकिन अगर इन्वेस्टिगेटिंग ऑफिसर मजिस्ट्रेट को सेटिस्फाई कर देता है कि इन्वेस्टिगेशन करना जरूरी है फॉर स्पेशल रीजंस और इंटरेस्ट ऑफ जस्टिस में ऐसा जरूरी है कि इन्वेस्टिगेशन कंटिन्यू की जानी चाहिए, तो देन मजिस्ट्रेट कैन अलाउ दैट इन्वेस्टिगेटिंग ऑफिसर टू कंटिन्यू विद द इन्वेस्टिगेशन. नाउ section 167 clause 6 lays down that if the magistrate orders the investigation to be stopped, अगर magistrate ने investigation को stop करवा दिया by his order under subsection 5, but the sessions judge is satisfied, लेकिन session judge satisfied है on the application made to him or otherwise that further investigation into the offense ought to be made, मतलब सेशन जज के पास मजिस्ट्रेट ने मना कर दिया, मजिस्ट्रेट सेशन जज सेटिस्फाई हो गया कि फर्दर इन्वेस्टिगेशन जरूरी है, और सेशन जज कैसे सेटिस्फाई हुआ, उसको एप्लीकेशन दी गई कि हमें फर्दर इन्वेस्टिगेशन करना है, तो सेशन जज अलाउड दैट इन्वेस्टिगेशन. फर्दर इन्वेस्टिगेशन इनटू द ऑफेंस ought to be made. He may vacate the order made by the magistrate. तो जो मजिस्ट्रेट ने ऑर्डर दिया था, सेशन जज उस ऑर्डर को वेकेट कर सकता है. Now, the sessions judge may direct further investigation to be made into the offence, subject to the directions with regard to bail and other matters as he may specify. Thus, the outer limit of 6 months for the completion of investigation can, on the satisfaction of the magistrate, under subsection 5, or the sessions judge under subsection 6, be extended, though only in exceptional cases, and no time limit is prescribed for further investigation, as I've already told you about. So this was all about section 167, and this section can be better understood by reading this flowchart along with whatever I have just said. So if there is any doubt with respect to this, you can leave it in the comment box. The same will be answered. And please do like and subscribe the video. Thank you.